So when I started reviewing his materials, I paid special attention to how he described his work on civil rights. And I noticed some discrepancies in the way he had described his involvement in civil rights cases filed during his time as a U.S. attorney. I asked Senator Sessions about these discrepancies during his hearing. I asked him about his claim that he had filed 20 or 30 desegregation cases, a claim he made in a 2009 interview with the National Review. In response, Senator Sessions said, quote, "The records do not show that there were 20 or 30 actually filed cases." He said of the claim, quote, "The record does not justify it." I then moved on to question him about 4 cases that he listed on his questionnaire, which asked him to list the, quote, 10 most significant litigated matters he personally handled. Among those 10 cases that he listed on his questionnaire were 3 voting rights cases and a desegregation case. Now, that surprised me, and that's because I know Senator Sessions and I know his record on voting rights. He's no champion of voting rights. He called the Voting Rights Act intrusive and complained about states with a history of discrimination being subject to preclearance. But here he seemed to be trumpeting his personal involvement in 3 voting rights cases and 1 school desegregation case. And I guess it just seemed to me that given his previous experience before this committee, and given the concern the civil rights advocates had expressed about his nomination, that perhaps Senator Sessions or the transition team was attempting to revise some of that history and to recast him as a civil rights champion. And as it turns out, that's exactly what was going on. 3 attorneys who worked on 3 of those 4 cases wrote an op-ed stating that Senator Sessions had no substantive involvement in the cases that he listed as being among the top 10 that he had personally handled during his entire career. And 2 of those attorneys also submitted testimony to that effect. One of them, Jerry Hebert, spent 21 years in the Justice Department's Civil Rights Division, during time which he litigated cases in Alabama and met Senator Sessions. Mr. Hebert also provided testimony to this committee in 1986, and much of it served as a basis for Republicans on that committee choosing to reject Senator Sessions' nomination to the federal bench. Now, after I questioned Senator Sessions about his claim of personally handling these 4 civil rights cases, Senator Cruz decided to weigh in on my line of questioning. He said that I had intended to undermine the nominee's character and integrity, and that my questioning was, quote, not backed by the facts. Senator Cruz then proceeded to mischaracterize and attack Mr. Hebert, whom he described as, quote, an individual who testified falsely before this committee. Let's talk about that. Back in 1986, Mr. Hebert and his supervisor at DOJ were called to the Hill without advance warning to be deposed. Mr. Hebert's supervisor incorrectly stated that when he was a U.S. attorney, Senator Sessions pressured the FBI to stop a voting rights investigation. Now, that was not the case. It wasn't Senator Sessions who did that. Mr. Hebert's supervisor got it wrong. He misremembered. When committee staff next deposed Mr. Hebert, he was asked whether he observed Senator Sessions interfere with DOJ cases. And Mr. Hebert replied, quote, I only know what happened with our Conecuh County case, but my supervisor is in a better position to talk about that than I am. Mr. Hebert continued, he and I both have a very fuzzy recollection about Conecuh County. It was my supervisor's case primarily. Then Senator Biden asked Mr. Hebert about this testimony the next day, and Mr. Hebert repeated the error. But after they testified, which again happened on very short notice, Mr. Hebert and his supervisor returned to DOJ and pulled the records from the case, from those cases. They themselves discovered their error. and they both immediately filed sworn declarations making clear that they were mistaken and that Senator Sessions did not interfere. It was Senator Sessions' predecessor who had interfered. Mr. Hebert and his supervisor did not recant their testimony. They simply corrected their testimony in writing in advance of the committee's vote on Senator Sessions. In Mr. Hebert's case, that meant he submitted a declaration in which he corrected 3 lines of testimony in what was a 24-page deposition, 3 lines. The rest of the testimony in Mr. Hebert's 24-page deposition was unaffected. But just to be safe, just to make sure that the committee didn't misunderstand the purpose of his declaration, Mr. Hebert made it crystal clear. He wrote, quote, "This revelation concerning the non-involvement of Mr. Jefferson Sessions in interfering in any voting rights investigations in the Southern District of Alabama does not affect in any way my other testimony rendered before the Senate Judiciary Committee on March 13th, 1986. Mr. Hebert's supervisor, who was the one responsible for originally getting the facts wrong, also testified in person to correct the record." That's what happened. Those are the facts. But when describing this history, Senator Cruz misrepresented what happened. So I'd like to take this opportunity to set the record straight.
I object to the senator disparaging a fellow member of the committee here in his absence. I would think he'd...
Well, he should be here, first of all. Secondly, he disparaged me,
do it to his
Senator.
face.
Let him make his case, and then we'll go back to you.
Sure.
I object to the senator. We're here to talk about the president's nominee, not a colleague. And I object to disparaging...
Don't take this from my time.
...disparaging a colleague on this committee, and particularly in the colleague's absence. It's just not... It's untoward and it's inappropriate, and I object.
Okay.
Can I speak to that?
You can speak to it, but I think that we'd be better off if we just let it go at this point.
You mean let me continue my speech?
Yeah, would you do that, please?
I will, thank you. But just to be safe, just to make sure that, okay, I did that paragraph. This is what happened. Those are the facts. But when describing this history, Senator Cruz misrepresented what happened. So I'd like to take this opportunity to set the record straight.
I object again. The senator apparently can't get the message from the chairman that this is over the top and inappropriate.
I think the senator from Texas doesn't get the message from the chairman.
You put the chairman in an awful bad position at this point because I'm not sure that I know
where I'm going.
I don't disagree with anything Senator Cornyn said, but I'm not sure I want to rule anybody out of order, but could you please leave personalities out of it?
Can I explain what I'm doing here? Because Senator Cruz did the very thing that Senator Cornyn is accusing me of doing. In my absence, he misrepresented me. He misrepresented Mr. Hebert. He personally went after me. He personally impugned my integrity. You didn't object then, did you?
Okay.
I'm not sure I was here, and I'm not sure
I wasn't
the
here
characterization.
either.
But
Let me continue,
It would be
sir.
a decent and honorable thing to do it in the senator's presence and not.
Well, get him here, but he'll have a tape of it. Okay. Allow me to read from the hearing transcript. This is Senator Cruz talking to Senator Sessions. And what I'm doing here is I'm clarifying Senator Sessions' record.
Proceed.
Senator Cruz, now earlier in this hearing, Senator Franken engaged you in a discussion that I think was intended to try to undermine your character and integrity. And in particular, Senator Franken suggested that you had somehow misrepresented your record. It is unfortunate to see members of this body impugn the integrity of a fellow senator with whom we have served for years. It is particularly unfortunate when that attack is not backed up by the facts. Now let's talk about who is trying to impugn the integrity of another senator.
This is from Senator Sessions.
I would suggest that Senator Cruz was trying to impugn mine. But if you take the time to really examine the evidence, you will see that he's not making his case at all. Instead, he deliberately elides the truth. And this is about Senator Sessions. Let's go back to the transcript. Senator Cruz. Senator Sessions based his attack primarily on an op-ed written by an attorney, Gerald Hebert. There is an irony in relying on Mr. Hebert. Because as you well known, in 1986, during your confirmation hearing, Mr. Hebert testified then and attacked you then, making false charges against you. And indeed, I would note, in the 1986 hearing, 2 days later, Mr. Hebert was forced to recant his testimony, to say that he had given false testimony to this committee, and indeed to say, quote, "I apologize for any inconvenience caused Mr. Sessions on this committee by my prior testimony." So an individual who has testified falsely once before this committee, his op-ed is now the basis for Senator Franken's attack on you. Let's unpack this. Mr. Hebert was not, quote, forced to recant his testimony. He voluntarily corrected an error that he discovered himself. The committee did not catch him in a lie. He did not try to pull one over on the United States Senate. That's not what happened. As I noted, Mr. Hebert originally testified that he had, quote, "a fuzzy recollection about the incident in question." Upon refreshing his recollection, he immediately and voluntarily corrected the record. But if you didn't know better, after listening to Senator Cruz, you would think Mr. Hebert was caught lying and that the entirety of his testimony was discredited. Again, this is just not what happened. Mr. Hebert did what a good lawyer does when he discovers he made a mistake. He forthrightly admitted his error, and he expeditiously corrected the record. But back to the transcript, Senator Cruz. And indeed, the basis of Senator Franken's attack is he claims you were uninvolved in several civil rights cases that were listed on your questionnaire. In 1986, Mr. Hebert testified, this is a quote from him, "I have needed Mr. Sessions' help in those cases, and he has provided that help every step of the way." Is that correct? That is what Mr. Hebert testified. Senator Sessions, yes, that is correct. Now, once again, Senator Cruz elides the truth. The 4 civil rights cases that I questioned Senator Sessions about during his hearing, the 4 he claimed that to have personally handled, this is Senator Sessions, the guy we're talking about confirming or not confirming. They were not what Mr. Hebert was talking about in that quote from 1986. Mr. Hebert worked on a number of cases in the Southern District of Alabama, and he was speaking about how he had interacted with Senator Sessions generally. Now, to be clear, Mr. Hebert had explained to this committee that 2 of the 4 civil rights cases that Senator Sessions claimed credit for personally handling are cases that Mr. Hebert litigated himself personally. They were filed before Senator Sessions was the U.S. Attorney, and Senator Sessions was not involved. Nonetheless, Senator Cruz attempted to conflate how Senator Sessions and Mr. Hebert interacted generally with Senator Sessions' quite limited involvement in these civil rights cases. But since Senator Cruz brought up the assistance that Senator Sessions provided to Mr. Hebert, let's talk about that. After Senator Cruz mentioned this 1986 exchange, I called Mr. Hebert about it. And he explained to me that, yes, Senator Sessions did provide assistance. When Mr. Hebert and his team needed to work weekends, Senator Sessions gave him a key to his office. Senator Sessions gave Mr. Hebert permission to assign work to his secretary once. Now, none of the occasions that Mr. Hebert referenced were related to the 4 cases that Senator Sessions listed in his questionnaire. But regardless, what Senator Sessions didn't do, to be clear, was personally handle any of the cases Mr. Hebert fired.